I'm Eric Syverson here with Steve Gebelin. It is an unusual day in that, Steve, you are actually wearing a suit and tie. So
Yeah.
I take it you were in court this morning.
I sure was. I had a motion to stay a case pending arbitration and won this morning. So
It's winning is always good, and in that spirit, I wanted to talk to you today about internet impersonation. You know, we do a lot of internet defamation cases. Sometimes it's anonymous, sometimes we know who's doing it, but there's another type of case that pops up time and again, which is a little different flavor, and that is someone will impersonate someone on most typically social media, Facebook, Google+, Twitter, Instagram, what have you. And so the question we get often is, can I sue over that, and who can I sue? So can you address what the legal claims would be in that situation?
well, you have a few different claims. One of them, and the strongest one that we have for this is actually based on a California Penal Code law that calls this kind of internet impersonation cyber piracy. It's for anyone that credibly poses or impersonates a person online to a third party, and those third parties are mistaken about who the...
That's my phone. That's the Hail to the Victors, the Michigan fight song. As a Michigan grad, I'm very happy right now with the Wolverines. Okay, back to the law.
So this claim is it's a misdemeanor under California law, criminal law, but it also gives a private right of action to anybody that's been harmed by this to bring a claim for damages, for attorney's fees. You can seek punitive damages under this for the impersonation.
Okay, well, let's focus in on that damages portion. I think that's important because there probably are not any great actual damages. In other words, there may be scenarios where a big business deal is lost, but typically not in our experience. It's certainly a wrongful act. But so the statute, if we're suing on this, will be eligible to recoup our attorney's fees. That's
right.
Important. And we can get punitive damages, correct?
That's correct.
Now, are there statutory damages, a certain minimum or maximum type of penalty we can get, similar to what you might see, let's say in an intellectual property case, copyright, for example?
No minimum amount of damages are necessary, so there's no specific damages you have to meet as a threshold to bring your claim, but there are also no statutory damage minimums that you get for bringing this claim. It's not tied to you get $1,000 for this, or you get $5,000 for this kind of claim. Instead, it's whatever damages you get are what you get. You can tie it to business deals being done, harm to your reputation that's been done by this impersonation.
Maybe emotional
distress damages, okay. For sure. That would be the carry-on claim that you would bring along with this, is an intentional infliction of emotional distress. Obviously, anybody that's doing this kind of impersonation, it's very reasonable to believe that they're doing it to cause you distress and harm. And the other part of an intentional emotional distress claim is that this is really beyond the pale activity. And again, this is not okay activity. It's not something that we think people have to suffer through daily life. Having someone else take their name and their identity online and present themselves.
It's very personal, and it's very troubling in our experience to our clients who have had to suffer underneath this, in this situation. It's very invasive and frankly very creepy. We see this popping up a lot with business executives and celebrities in certain situations, and like a lot of these defamation cases, our challenge typically, the primary challenge is to find out who the hell is perpetrating this, because they do this anonymously. So of course, if it's a fake Twitter account, our starting point would be to file a lawsuit for these claims against John Doe and then send a subpoena to Twitter and then follow the evidentiary trail to find out who the bad person is. So we talked about the statutory claim itself. We talked about an emotional distress claim. Is there possibly just a generic invasion of privacy claim? Although I'm not quite sure what else. I'm not quite sure what added value that would provide. But would that be something that could be brought?
It would probably depend on the nature of the statements being made in the impersonation, whether they're disclosing private facts about the person. That's the typical invasion of privacy claim that you would see here. So if they're going online and posing as you and also disclosing something you keep private in your own life and isn't disclosed to the world, then that's the kind of situation where we'd see that. Similarly, if they're saying false things about you, saying, for example, hateful racist things that you wouldn't say, that could support a claim for defamation.
Or obviously false light too. So, okay. Well, this is a scenario we see popping up more and more. I think we also see it popping up in conjunction with data breach or fraud issues. So the fact scenario you could see is someone posing as a corporate executive, authorizing some sort of payment on an accounts payable. So it happens in conjunction with a lot of typical scenarios. We'll see data breach, defamation, but it can also simply be driven by ill motives to inflict emotional harm or to get revenge. Right. We see it a lot of times in revenge situations, highly personal cases, family disputes. So what we want to tell the public is if this happens, and it's happening increasingly, at least in California, and there are other states with similar statutes, but in California you do have a claim and you can recover significant financial damages potentially in addition to your attorney's fees. So that's all we have for the Rains-Feldman Cyber Liability Update today. We'll see you next time.